This is the second in the series of presentations on the 2013 Jackson reforms to civil litigation in England and Wales. This one is dealing with the subject of costs management. Now, one of the most fundamental changes is to the overriding objective. Before the 1st of April 2013, the overriding objective was stated to be enabling the court to deal with cases justly. That's now been altered so that it now reads that the overriding objective is enabling the court to deal with cases justly and at proportionate cost. This high-level provision is given concrete effect through the detailed costs management procedures, which we're now going to have a look at. A further fundamental change to CPR1 is likely to give judges additional confidence when considering how to enforce compliance with rules and practice directions and orders and such like. These enforcement activities on the part of judges are part of fulfilling the overriding objective. When it comes to seeking relief from sanctions which the court might have imposed, a great deal of case law has clustered around the original provisions of CPR 3.9, but from April 2013, the relevant provision has been radically altered. On an application for relief from sanctions, the court must consider all the circumstances of the case so as to enable it to deal justly with the application, but the court is especially required to address the need for litigation to be conducted efficiently and at proportionate cost, and also the need to enforce compliance with rules, practice directions and orders. In the exercise of its general case management function, the court's given the power to contact the parties to monitor compliance with directions, although it must be questioned whether many case management judges will have the time or facilities to be very proactive in this area. The detailed new costs management regime has applied to all cases on the multi-track which were commenced on or after the 1st of April 2013, except those in the Admiralty and Commercial Courts. The purpose of cost management is related back to the overriding objective. And to understand how the timing works, first we need to have a look at the revised rules for allocation notices. Now, under the new CPR 26.3 dealing with allocation notices, once a defence has been filed, the court will provisionally allocate the case to a track and serve a notice of the proposed allocation on the parties. That this notice can itself contain directions to do something within a specified period, and it will require the parties to complete a directions questionnaire. Unless the case has been provisionally allocated to the small claims track, then it will also require the parties to file proposed directions by a specified date. The key point for present purposes is that the notice of allocation will also specify the date for filing and exchanging budgets. Should the notice fail to specify a date for this purpose, then by default the budget must be filed and exchanged 7 days before the first case management conference. Now, although a litigant in person is not required to prepare a budget, they are entitled to receive the budget prepared by the lawyers for the other side. Now, there's a prescribed form which is available as an Excel spreadsheet on the Court Service website, known as Precedent H. The completed budget in Precedent H form has to be dated and verified by a statement of truth. There's a restriction on the costs which are recoverable for preparing the budget, that is to say £1,000 or, if it's higher, 1% of the approved budget, unless there are exceptional circumstances. In substantial cases, the court may direct that budgets are to be limited to some part of the proceedings rather than, as normal, applying to the whole case right the way up to judgment following trial. In a moment we'll see a copy of the first page of Precedent H, and in smaller cases, that is cases where a party's budgeted costs should not exceed £25,000, the first page will be the only page which has to be completed. The rest has to be completed in more substantial cases. Now, this requirement to complete the thing requires that individual stages in the litigation are addressed in separate rows within the spreadsheet, and that in relation to each stage the budget reveals the costs already incurred, estimated future costs, disbursements, and provides a total of those things within each line. We'll now look at the individual stages or lines within the spreadsheet and provide some guidance on what should and should not be included. The first stage or line is pre-action costs. Now, figures, that is to say, once again, past costs, expected future costs, disbursements and a total, should be included for pre-action protocols correspondence, claims investigation, advice to the client, settlement advice, and all other pre-action steps and advice. Work already done in relation to later stages, for instance, if draft particulars of claim have already been prepared at the pre-action stage, that should not be put in at this pre-action line, but that should appear at the later stage. The next stage is statements of case, including the preparation of the claim form, issue and service of the claim form, preparation of statements of case, considering the other side's statement of case, Part 18 requests, and instructions to counsel relating to all of those things. If it's predicted that amendments will be required to statements of case, the relevant budget figure is a contingency and should not be put in this line. The next line or stage is the case management conference. This means the first CMC and not any subsequent one. Subsequent CMCs are to be treated as contingency items. But it does include completing the allocation questionnaire, arranging the CMC, the preparation of the costs budget ahead of the first CMC, agreeing directions and budgets, and attendance at the CMC. The next stage or line is disclosure of documents, and this doesn't include specific disclosure or third-party disclosure, because both of those are to be treated as contingency items which go elsewhere. But it does include obtaining documents from the client, advice on disclosure, review of the documents, listing them, giving and obtaining inspection of documents, and correspondence with the other side and your clients concerning disclosure, and seeking counsel's advice on disclosure. The next stage is witness statements, and that includes identifying witnesses, interviewing those witnesses, preparing statements and witness summaries, reviewing the other side's witness statements, associated advice and applications for witness summaries, but it doesn't include liaison with witnesses for the purposes of attending trial or obtaining witness summonses, because those two things have got to go into the trial preparation line instead. The next item is experts' reports, and that includes identifying and engaging experts, instructing them, reviewing their drafts, dealing with follow-up questions, considering the other side's expert reports, and legal work associated with meetings of experts. But it doesn't include seeking permission for expert evidence at the CMC, which has already gone into the CMC item, or if a separate application is made, a freestanding application for permission to call an expert, it doesn't include that either, because that counts as a contingency item. Neither does it include arranging for experts to attend trial. That goes into the trial preparation line. The next stage is the pre-trial review. That includes preparation of the PTR bundle, preparing updated cost budgets and reviewing the other side's cost budgets, the preparation and agreement of the chronology, a case summary, a dramatis personae, completing and lodging the pre-trial checklist and associated correspondence with the other side, and attending the PTR. But assembling the PTR bundle and copying it, as distinct from selecting documents to go into it, is not counted as legal work and should not be included in this line. The trial preparation item includes the selection of documents for the trial bundles, though once again not assembling and copying them, witness summonses, and arranging for witnesses to attend trial, any further factual investigations, supplemental disclosure and pre-trial conferences with counsel and the like. It includes pre-trial liaison with witnesses and agreeing a brief fee, but it doesn't include counsel's brief fee and any refreshers. The trial item includes the solicitor's attendance at trial, conferences with counsel associated with trial, attendance of witnesses during the trial, counsel's brief fee and refreshers, and dealing with the draft judgment and any associated applications. But it shouldn't include any element of preparation for trial or agreeing the brief fee. That has gone into the previous line relating to trial preparation. The next item is settlement, and that includes settlement negotiations at any stage, including making and receiving Part 36 offers and advising the client on them, drafting any settlement agreements, Tomlin orders and the like, and advising the client on settlement after the claim has been issued. Advice on settlement before the claim should go into the pre-action phase. This section, this line, does not include mediation, because that's to be treated as a contingency item. So moving on to the contingency line or lines, contingent costs are those anticipated costs which don't fall within one of the other categories. And by way of example, costs associated with the trial of a preliminary issue, mediation, an application to amend statements of case, an application for third-party disclosure. The consequences of failing to file a budget is that unless the court orders otherwise, under a later costs order, the party in question will be treated as if they will only be seeking to recover court fees and not costs. The new rules introduce the idea of a cost management order, which will record the extent to which budgets have been agreed between the parties, and where there's no agreement, or complete agreement, the court will approve budgets after making any appropriate revisions to the budgets that the parties have put forward. Once a cost management order has been made, the court will control budgets and therefore recoverable costs. If a hearing is convened solely for the purposes of cost management, that hearing is to be referred to as a costs management conference, and ideally it will be conducted on the phone or in writing and not in person. Where significant developments in the litigation warrant it, each party must revise its budget in respect of future costs, up or down, and then submit the amended budget to the other side for agreement. If agreement is possible, then that agreed budget has to be submitted to the court. If it's not possible, then the court will be asked to rule on the amended budget, and you'll have to accompany your application with an explanation of the changes and a note of the objections that have been made by the other side. The court then sets a revised budget, either by approving or varying or disapproving the revisions. And in doing so, the court has to have regard to any significant developments which have occurred since the last budget was approved or agreed. Now that language, having regard to significant developments, suggests that increases will not readily be approved in the absence of some turn of events which can properly be described as a significant development. Once the budget has been approved, it must then be refiled and reserved. And the role played by the costs budget is twofold. First, the court has regard to the budgets prepared by both parties when it's making case management decisions. Now that will be so whether or not a costs management order has already been made. Secondly, if a cost management order has been made, then any subsequent assessment of costs on the standard basis will not only have regard to the last approved or agreed budget of the receiving party, but actually the measure of costs allowed on assessment will not depart from that budget unless the court is satisfied that there's a good reason to do so. Now, the language here is really quite curious. You'd expect that without good reason the receiving party should be confined to their last approved or agreed budget. However, the language here seems to go beyond that so as to entitle the receiving party to the sum set out in their last approved or agreed budget, even if the bill of costs for assessment has been drawn in a lower figure. Now that does seem surprising, not least because it appears to depart from the indemnity principle, and that may just be infelicitous language. On assessment, interim applications made during the course of the litigation, which were not included in the budget, should, on a standard basis assessment, be allowed as extra items, subject to normal detailed assessment criteria. Now that's that all on this second presentation. A later presentation will deal with cost capping orders. Thank you.